Good evening, everybody. Welcome to today's webinar. This is the second webinar organized by the Ministry of Health and QualityRights Kenya in this COVID pandemic period. I'm going to start off by introducing our panelists for today's session. Our first panelist is Alberto Vasquez. Alberto works as a research coordinator at the Office of the United Nations Special Rapporteur on the Rights of Persons with Disability. He is a Peruvian lawyer and who holds a master's degree in disability, law and policy from the National University of Ireland. He's a member of the American Network of Psychosocial Diversity and has served as a consultant to various UN agencies on human rights, disability, and mental health, including WHO, ILO, UNICEF, and OHCHR. He's also served as the president of the Peruvian NGO Society on Disability. He was actively involved in drafting and advocacy related to the Peruvian legal capacity reform. Welcome, Alberto. Our second panelist is Michael Njenga. Michael is Executive Director of Users and Survivors of Psychiatry in Kenya. He's also the Executive Council member of Commonwealth Disabled People Forum and the chairperson of Pan-African Network of Persons with Psychosocial Disability. He's a self-advocate and passionate about advocating for rights of persons with mental and psychosocial disability and the right to legal capacity and inclusivity in the society. And this enables every person with disability to enjoy their human rights.
Hello, everybody. Thank you for this invitation to be part of this webinar. I think we're gonna talk today in a very important topic, not only in the framework of mental health services, but in general, in the framework of how we ensure the rights of people with disabilities, including people with intellectual and psychosocial disabilities. I think the first question we may want to address is, what's legal capacity and why it's important? Legal capacity has been described many times as the right to exercise rights, because it means the capacity to make legally binding decisions such as voting, getting married, having children, entering into a contract, and that includes daily life activities like opening a bank account, getting a new phone, signing a working contract, deciding about property, deciding where and with who to live, and very important to this discussion today, consenting or refusing treatment. So legal capacity is really at the heart of the Convention on the Rights of Persons with Disabilities, and is essential to both enjoying and exercising rights. Without legal capacity, we cannot talk about inclusion or participation in society, and people with disabilities would be left behind. For most people, the capacity to exercise rights is a given. It's something you acquire when you become an adult. So we don't really talk about legal capacity that much. But for many people with disabilities, for too long, the reality is denial of legal capacity. And this is the reality in most legal systems in the world. And this particularly affects some people with disabilities, people with intellectual disabilities, people with psychosocial disabilities, people with autism, people with dementia, and those with high support needs. How is legal capacity denied? Restrictions to the legal capacity could be based in different ways. Could be based on the fact that the person has a medical condition, a diagnosis, or an impairment. Sometimes it could be based on the fact that the person has made decisions that other people consider that are inadequate. Or sometimes, as in many legal systems, restrictions to legal capacity are based on the fact that the person is deemed as not having certain mental capacities to make decisions. And those restrictions on the legal capacity can manifest in many ways. I think that the most known way is guardianship. Guardianship that could be total or partial, and it will affect the exercise of all or most of the rights. But restrictions to the legal capacity can also affect people in very specific areas of life. For example, this is the case of restrictions on parental rights, or in a case that probably is familiar to you, restrictions through mental health legislation. Because at the end, a judge or a doctor will decide for the person, even against their will, if they can receive or not treatment. But there is a third way that legal capacity is denied. I would say is the most common way of denial of legal capacity in global South countries. And this is de facto denial of legal capacities, when relatives, caregivers, public servants, doctors do not allow people to make decisions about their lives or request that somebody else is present to validate their actions, even if they are not legally incapacitated. And the consequence of these restrictions is normally something we call substitute decision-making, which means basically that somebody, a third person, will make decisions on behalf of the person, and could be a guardian, could be a judge, could be an expert, could be a doctor. This also involves limiting the capacity of the person to make legally binding decisions, even if it's just for a single decision. And these decisions will be made on the best interest of the person, not actually on what the person wants or express. So why legal capacity? Why denial of legal capacity and substitute decision making is problematic? And I will give you 4 ideas that I think are key for this discussion. First of all, is discriminatory. These different forms of denying legal capacity and substitute decision making basically affects people with disabilities, particularly those more vulnerable, as people with intellectual disabilities and psychosocial disabilities. It denies their agency and autonomy, and that means the possibility of exercise the rights by themselves or with the support of others. And I would say that it further denies human diversity, because we know that we are all different and we have different ways to express our will and preferences. So this substitute decision-making basically interrupts the development of our decision-making skills. A second, I think, key important argument is it doesn't achieve the foreseen objective of protecting the individual. And it's always argued that those substitute decision-making regimes, whereas guardianship or involuntary treatment, aim for protecting the individual. But the big question is, does it work? Because they mean putting all the power to make all the decisions, often about all aspects of life, including treatment, over one person. And that's a lot of responsibility, and that's a lot of power. So we know that in practice, with people under guardianship, but also people that have been denied of the legal capacity on one or many areas of life, face abuse and conflict of interests. And we know that family members are not gonna be, we expect that family members to be the guarantee for the protection of rights, but in practice, we know that family members are not, especially when the parents are not around anymore. So the situation of conflict, abuse, and undue influence is very common in these regimes. And going specifically to the issue of mental health services, I think also that it's something to think about is the fact that there is no empirical evidence that involuntary hospitalization, for example, which is a form of substitute decision making, reduce the risk of suicide or self-harm. Actually, some evidence, on the contrary, shows that it could prevent people to access psychosocial support and treatment, because some people with suicidal thoughts may stay away from services if they think they're going to be coerced. And this also creates conflict in the clinical relationship, which we know it should be at the heart of patient-centered care. A third argument is that these measures are no longer necessary. I don't think they were ever necessary, but I think we can build now the argument from practice that other restrictive means could be used. Other not restrictive means could be used. For example, we can use advanced directives. We can allow people planning in advance how to deal, for example, with a crisis situation. We can use now something that the Convention on the Rights of Persons with Disability puts forward, supported decision making, the possibility of being supported to making legally binding decisions instead of being denying legal capacity. And this can work even for the hardest cases where intense support is needed. But the big difference will be that support will act based on the best interpretation of the will and preference instead of trying to decide what's on your best interest. We also know from practice that there are many alternatives to coercion, from hospital-based strategies to prevent coercion to community-based alternatives. And that includes in crisis support services at the home, crisis resolution services, respite services. I think practice is showing us a way out of this idea that the only possible response to difficult situations is denying people rights. And let's remember something that is important. Nobody here is advocating for doing nothing. I think nobody is advocating to refrain to intervene when people is experiencing crisis. What we're advocating is to support people in crisis situation, but without taking away their autonomy and dignity. And a final argument that I would like to do is that those regimes are not proportional, because people lose the capacity to exercise rights and decide about their lives and treatment. But also people lose the capacity to challenge the denial of such rights, because denial of legal capacity also affects the possibility to access justice. And just having the possibility, for example, of a doctor making a decision about your treatment without your consent, in practice becomes a threat. Even if you can agree voluntarily or not, you may be coerced. So you may agree to an unwanted treatment just to avoid to get to that situation. And to finalize, let me be a lawyer for a moment, to put an extra argument. Denial of legal capacity and substitute decision making is against international law, because many countries, including Kenya, have signed the Convention on the Rights of Persons with Disabilities. And doing so, they have made an international commitment to comply with it. So to conclude, let's remember that the Convention on the Rights of Persons with Disabilities call us to rethink mental health law and practice, particularly in relation to legal capacity and coercion, because the Convention is seeing people with disabilities right holders with the same rights as everybody else, not objects of protection, charity, or treatment. So we have to push ourselves to think beyond these liberal conceptions of rights and society and recognize the interdependence of the human experience. We're social beings and our autonomy is the result of human interaction, not just an attribute that is innate to some individuals and can be tested. So we need to start thinking really about how we operate under this new support paradigm, how we support people to exercise rights, how we support people who is in crisis, how we support people to recover, how we support people to live independently in the community. Thank you.
Rights. Welcome, Michael, to today's discussion.
Thank you very much, Jackie, and I think it's an honor to be able to participate in this particular webinar. I think it's always difficult to speak after such an eloquent speaker like Alberto, but I think nevertheless, I'm going to pick up from where Alberto left and really emphasize that in terms of inclusion of persons with psychosocial and intellectual and cognitive disabilities, it is extremely difficult for them to enjoy all their fundamental rights and freedom if they cannot be recognized as persons before the law. And this, I think, Alberto have rightly explained, and this basically also moved to them being able to participate in all matters pertaining them on an equal basis with others. So for me, the recognition of full legal capacity for persons with psychosocial, intellectual, and cognitive disability is very, very important in terms of them being able to fully and effectively participate in the society on an equal basis with others. And I think the next thing I want to say is that Kenya, of course, have ratified the Convention on the Rights of Persons with Disabilities. And the Committee on the Rights of Persons with Disabilities, in its general comment number 7, which is about full and effective participation of persons with disabilities through their representative organizations, including children with disabilities, really lays an emphasis on the importance of persons with disabilities being effectively consulted in all matters that actually are affecting them. And I think I want to really emphasize that the active and informed participation of everyone in decision-making, not only persons with disabilities, is consistent with the human rights-based approach in public decision-making processes. And this ensures good governance and social accountability. So I think that's very, very core. So I think when you're talking about supported decision-making, it's basically involve a person or an individual making decisions through the support of a trusted friend or networks of friends. And I think one important core principle in the whole issue of supported decision-making is the overarching principle is of course always respecting the will and preference. And I think this is something that Alberto have really emphasized, that it is core when we are supporting people with intellectual, people with psychosocial disabilities, to ensure that we respect their will and preferences. And in circumstances where we are not able to determine a person's will and preference, then we must ensure that we take all the necessary steps to ensure that then we are able to interpret what is what could be the best interpretation of will and preference, other than shifting to the principle of best interest, which normally is associated with substituted decision making. So I think, so in practice, for example, looking at the Kenyan context, then how do people with intellectual, psychosocial, and cognitive disability, for example, enjoy the right to make their own decisions and to have those particular decisions, of course, respected by others? I think we have, for example, one core important thing in decision making is, of course, ensuring that information is in accessible format, that all persons with intellectual, psychosocial, or cognitive disability can be able to understand. Because at the end of the day, it's difficult, for example, to make decision if you cannot be able to understand or have information in an accessible format. So even as we have conversation around, for example, COVID-19, it is very, very important we think around the accessibility of information. And I think it's not only health information, it involves also other measures that, for example, governments are taking towards mitigating the effects of COVID-19. So for example, if they are instituting a curfew or a lockdown, or if, for example, they are offering social protection schemes is all that information accessible to persons with intellectual and psychosocial disabilities. So that's very, very important, because I think generally there have been a focus only on providing health information in accessible format. I think the other important thing is, of course, ensuring that a person understands the options and the consequences of their decisions. And I think this is, for me, is very, very important, especially in the context of mental health care. Because, for example, more than often, and this is quite practical, people, for example, would be put on ECT without necessarily being given, I mean, what is electroconvulsive therapy? I mean, what are the benefits? What are, for example, the side effects of it? What are the alternative or the next available option? I think that is very, very important. And I think in an African context, we really have to appreciate the role of families, that they play a very, very important role in providing support to persons with psychosocial, intellectual, and cognitive disabilities. And I think mostly we see that, especially within the African context, that the family act as the natural form of support. And I think it's very, very important to recognize the important role that families play in the provision of support, but really, really emphasize that such support, of course, must respect the inherent dignity, the personal autonomy, and the will and preference, which in some circumstances, of course, it does not always work like that. I think all of us have circles of friends. I mean, just like, you know, and this, I think it's not just about people with disabilities. Even other people realize, they consult when they are making a particular decision, probably from their friends. So even persons with intellectual or psychosocial disabilities can have circles of friends who are very, very useful in terms of supported decision making. We have, for example, peer support, which is very specific, of course, to persons with psychosocial disabilities. And I think the other thing is, we really have to look within our communities and look at other ways in which people can be able to make support which they might require in making certain decisions. So, for example, we have social workers in Kenya, we have community health workers in Kenya, and we have to explore what role do they play in the provision of support within the paradigm of Article 12, within the paradigm of Article 12. I think the other important thing I want to say is, so how does probably the exercise of legal capacity, or the right to make your own decisions and to have those decisions respected by others, impact on the overall well-being and recovery of a person? I think for too long, discussions around the rights of persons with intellectual and psychosocial disabilities were reduced only to conversations around mental health. And I think we need to really think about recovery and the overall well-being of a person within the wider frame of inclusion, and seeing mental health, you know, as one component that every person requires in order for them to be able, you know, to live independently and being included in their community. So I think for me, if we're talking about the inclusion of persons with psychosocial and intellectual disability, then I think the shift the shift must move away solely at looking at mental health alone, but rather a greater recognition that in order for people with intellectual and psychosocial disabilities to fully and effectively participate in the society on an equal basis with others, then we need to reframe the conversation and explore the kind of changes that we require in different areas in our lives. So it's just not about mental health. So for example, what about education? What about social protection? What about employment and decent livelihoods? What about things like access to justice? What about support services? So I think in order for us overall to ensure the overall well-being of people with intellectual and psychosocial disabilities, it's very, very important to look at things like the social determinants of health. We have to address the existing inequalities. We have to look at other socioeconomic factors. So I think for me, the whole discussion around inclusion cannot be framed within the context of mental health, but rather we have to look at it a bit more broadly. And I think in conclusion, I would like to reflect in the context of COVID-19, what specific measures do we need to take to ensure the full and effective participation and inclusion of persons with psychosocial, intellectual, and cognitive disabilities? And I think the first thing, of course, to make sure that in all policies and programs relating to COVID-19, then they are fully and effectively consulted through their representative organizations. And this is something which is highlighted in the convention on Article 4.3 and 33.3, and also on the general comment number 7, which have been developed by the Committee on the Rights of Persons with Disabilities. And I think the second thing is about accessibility of information, because if persons with intellectual and psychosocial disabilities cannot have every information they require in the context of COVID-19 in accessible format, in ways that they can be able to understand, then it is very, very difficult for them to be able to, for us to be able to achieve inclusion and for them to be able to participate in any process relating to, COVID-19. And I think, thirdly, I think the Convention on the Rights of Persons with Disabilities provides some specific mechanisms. So if we look at Article 33(2), it actually establishes or clarifies the role of national human rights institutions. And I think this is something that we've seen in Kenya when we are engaging around issues to do with COVID-19 with government. For example, during the submission that was made by the Senate to the Senate committee which is dealing with COVID-19. I mean, this was done through the Kenya National Commission on Human Rights and of course in collaboration with other actors. So I think it's very, very important to look at those kind of existing structures and how they can be used to ensure the full and effective participation of organizations of persons with intellectual and psychosocial disabilities. And I think also opening up spaces for collaborating with other organizations and other civil society actors is very, very important. And critically strengthening support services, which are very, very critical in the exercise of legal capacity, which is a prerequisite for full and effective participation. I think for me, that is very, very important, that we need to strengthen peer support. We need to strengthen, for example, the role of social workers. We need to strengthen the way families provide support. We need to look at how we reform, for example, our mental health laws to ensure that we are able to embrace the paradigm shift that is envisioned in the CRPD. So I think those would be some few reflections in terms of, in the context of COVID-19, what are the specific measures that we might need to take to ensure the full and effective participation and inclusion in line, of course, with the principles of the Convention on the Rights of Persons with Disabilities. Thank you.
Thank you very much, Michael and Alberto. Just to continue with our discussion before we go to our Q&A session. This goes to Alberto. Are there instances where persons with psychosocial, cognitive, and intellectual disabilities have been denied a voice?
Well, I would say that has been the general rule, that people with intellectual and psychosocial disabilities have been denied their voice, though thanks to organization and activism, I think their voice is getting louder and louder and is pushing for change. I think the adoption of the Convention on the Rights of Persons with Disabilities has been a big milestone in getting that voice louder. And we know also that in many countries, change is happening thanks to advocacy. And I want to put an example, my own country, Peru, a country which is not so different from many other countries in the global south in terms of limitations on access to resources. And we don't have a lot of institutions, we don't have a lot of people under guardianship because in practice, restrictions happen in society, in the communities. But with all of this, what we have seen in the last 10 years is major transformation in legal and policy framework in terms of a big reform on legal capacity that now recognize legal capacity of all people with intellectual and psychosocial disabilities, that incorporates in our legislation different measures for supported decision making. In the last 2 years, we have seen change in the mental health legislation that now is opening up towards how we include the discussion on legal capacity in the framework of the work of the mental health services, which I think is very important. I agree with Michael that we cannot reduce all the discussion to mental health services when we talk about people with psychosocial disabilities, but at the same time, regretfully, we cannot avoid the discussion about mental health services because it's a big part of the problems with denial of legal capacity. So I think everything is related. But as I said, the voices are getting louder, and I think that's important because we can see change. And the good thing is, 10 years ago, really, when we discussed legal capacity at the international level, everybody will look at each other thinking, okay, but how we're going to realize this? How we're going to implement this change that the convention is bringing forward? I think today, now we have good examples, especially in my region, in Costa Rica, in Colombia, in Peru, of how you can implement a system that actually aligns with this high aim of respecting all people's rights.
Thank you very much, Alberto. And to continue our discussion, I want to raise a concern, and this goes to Michael. One of our audience members has noted that Kenya has just adopted the Data Protection Act, which states that data subjects with mental illnesses can only access their information with consent from a guardian. So how does this interfere with what we are trying to lobby for and what we are trying to work towards of ensuring that everybody has access to legal capacity?
I think we have to reflect to the fact that, of course, Kenya was reviewed by the Committee on the Rights of Persons with Disabilities in the year 2015. And the Committee on the Rights of Persons with Disabilities made some concluding observation in relation to the way Kenya as a state party to the convention should, what kind of measures it should take to ensure that persons with disabilities, of course, enjoy their fundamental rights and freedoms on an equal basis with others. And I think then one of the key areas in terms of recommendations was around Article 12, and it's about reforming all the laws that deny persons with disabilities, specifically persons with psychosocial and intellectual disabilities, and ensuring that we recognize their full legal capacity, irrespective of their mental capacity, which is the decision-making capability that differs, or ability that differs from one person to another. So I think I think Article 2.6 of our Constitution is very, very clear that anytime we sign an international treaty, then automatically, by virtue of Article 2.6 of the Constitution, it becomes part of our domestic law. So I think that for me is a clear contravention, of course, of our international obligations under the CRPD, because at the end of the day, everyone is presumed to have legal capacity. And even the whole discussion around the Data Act should be then what kind of, so first there's the recognition of full legal capacity. The second issue is then how do we ensure or do we provide the necessary supports to ensure that persons with intellectual or psychosocial disabilities are able to access data on an equal basis with others. Because I think for me, the question is, why is it for other peoples who might have difficulties in decision making, then we do not deny them that particular right, but then we are setting a different standard. So I think that this for me is contrary to obligations which Kenya as a state party have committed to under the Convention on the Rights of Persons with Disabilities. And I think continuously we should engage in the process of legal harmonization to ensure that our laws are aligned with our international obligations.
Thank you, Michael. As we continue the discussion, Alberto, I'll throw this back to you. Alberto?
Yes.
How can inclusion of persons with psychosocial, cognitive, and intellectual disabilities voices be achieved during this COVID-19 pandemic period?
Yeah, I think that's a good question. I think on one side we need to go back to the importance of participation of people with disabilities, and in particular people with intellectual and psychosocial disabilities, in the process of designing and implementing these policies. I think consultation, but beyond consultation, real engagement is important so we can ensure that services respond to people's needs. And of course, when we talk about particular services, this is key. We have seen internationally that in many countries, people experiences a lot of difficulties, not only in dealing with the lockdown measures, but particularly in accessing services that has been cut or to the social protection benefit that has been implemented. And I think it's important how we ensure this inclusion. It has to depart from participation and engagement. But more concretely, thinking about legal capacity, which is what we want to discuss today, it also means that I think it's important that, particularly when we talk about mental health services, we start from the perspective that every single person has the same rights. Because we have seen, and reading the comments in the chat, that in some countries, lockdown measures are affecting particularly those in hospitals. They are not allowed to leave the rooms, they are not allowed to have visits, they are not allowed to in general, even to just go to the garden. And of course, what kind of recovery you're going to achieve in such situations. So, and we think, but there is no alternative due to the crisis and the COVID crisis. And I think, again, this is about discussing and finding solutions with the people in services that can accommodate different people's needs. Today I was reading, for example, in the UK, they have issued a clear guidelines today about the fact that in the UK, for example, they have these involuntary measures in place. That doesn't mean that you can detain people with psychosocial disabilities just to prevent them from spreading COVID-19, because that was not the purpose of this legislation. Even though we're already contesting this legislation, it's important that it's not even used further to restrict people in the context of the COVID-19 crisis. So I think it's important that we go back to this very basic fact, how we ensure everybody enjoys rights in an equal way.
Thank you, Alberto. As we continue our discussion, Michael, I'd like you to help us understand the Kenyan context of inclusion of persons with psychosocial disability during this COVID period. And just to give an extension of that, would it also be okay for you to give us the impacts of the voices, of inclusion of the voices of persons with psychosocial disabilities in their own well-being and in their recovery?
I think we have to reflect even before COVID that certainly people with psychosocial, intellectual, and cognitive disability, they are a group who are, highly marginalized. And I think that's something that we have to recognize, that even before COVID, this basically was, it's always been a problem. whether it is even inclusion in the disability movement, finding their space in the disability movement, I mean, within the society, within the communities. I think they face enormous challenges in terms of their the inclusion even before we had COVID. Of course, now with, COVID-19, of course, put them at a higher risk of even greater marginalization. And I think, so just to give, for example, some practical examples is, so government is refocusing a lot of their resources, whether technical or financials, towards addressing issues relating to COVID-19. Then this essentially means that then it's difficult, for example, for people with psychosocial disabilities and intellectual disabilities and other cognitive disabilities to access, for example, specific mental health services that they might need, or even other rehabilitative services that they may need, of course, in relation to their health needs. So that's something which is actually emerging, and we have, of course, some documented case in relation to that certainly they're not able to access those services. I think the second issue and challenge here have always been that we've never really invested in community-based services and other alternatives, for example, in the context of mental health. So, I mean, and we are creating a situation whereby there is restriction in movement. So I cannot move from one region to another to access services. And we've not developed comprehensive community-based services within our communities. So with measures like, I mean, curfews and lockdowns, and the fact that you cannot move from one county to another, I think this certainly is putting persons with psychosocial, intellectual, and cognitive disability even at a higher risk, especially where they might require specific or specialized services, and they cannot be able to move from one place to another. So that for me is I mean, challenges that I have to point out. So, I mean, and I think I've pointed out systematically, I think there are efforts to ensure inclusion of organizations of persons with disabilities. And this, for example, I can be very specific through, for example, our umbrella body, United Disabled Persons of Kenya, working collectively within the disability movement and making sure that, of course, that we are able to engage with different government ministries, departments, and agencies. And I think, secondly, I've also pointed out the important role, of course, for example, the Kenya National Commission on Human Rights and other institutions like the National Gender and Equality Commission are playing in ensuring the inclusion of marginalized groups. And I think also to be specific is that I think deliberately, for example, I know in the area of inclusive education, that organizations of persons with intellectual disabilities are engaging, for example, with the Kenya Institute of Curriculum Development together with UNICEF, because of course there's a big problem in terms of inclusive education, specifically for people with intellectual disabilities. So I think there are enormous challenges in terms of engaging, but I believe there are also some deliberate efforts to ensure that our voices, of course, are heard and they are included in different government policies and programs that are being implemented. But I think one key point one thing which I think is very, very key is in relation to social protection, and especially because most of the people with intellectual, psychosocial, and cognitive disabilities and their families, of course, I mean, they live in abject poverty. And I mean, and one of the problems, again, which you're encountering is their ability to access social protection measures in this particular country, because most of them, due to systematic challenges, are either not registered as persons with disabilities, or even where there are programs specifically to provide social security measures, then because they have invisible disabilities, they are sometimes being turned away, for example, when food is being offered within their communities. And I think then we really need to address some of, these emerging challenges, even as we try to advocate for the inclusion of persons with intellectual, psychosocial, and cognitive disabilities.
Thank you very much, Michael, and thank you very much, Alberto. This has been a very engaging conversation. I know this topic is very wide and we are not able to cover it within one webinar session, but we hope that with the continuity of time, we'll have many more sessions. So I'll give you both a few minutes just to give us your parting shot before we come to the end of this session. We'll start with you, Alberto.
Thank you. It has been great to be part of this conversation. I just want to emphasize something that I think it comes all the time when I talk with, especially with service providers, that this is a problem. The issue of legal capacity is a problem of the law and not a problem with practice. And actually, it's not true. One of the main challenges we see is actually in practice, in how service providers directly respect or not the legal capacity of people. And we also have seen the change actually comes from practice. When we think about, for example, mental health services that have stopped coercion or are really reducing to the minimum the issue of involuntary practices in general, those have been services that have made a decision, a conscious decision to stop doing it. And they have to restructure the way of working to achieve that goal without a law that actually supports that practice. And this is the example of Lapland in Finland. This is the example of Trieste in Italy. This is the example, or what they're trying to do in Marseille in France. So those has been conscious decisions of services trying to change and to respect people's rights. And when we think about the COVID-19 situation, I think services can take the lead. I like that in my own country, in Peru, the Ministry of Health has said expressly that we cannot force people to be in services where they are at risk of getting infected. So I think these kind of messages, this kind of political message is very important because it recognizes this power imbalance that exists, and I recognize the inequality that can create the fact of being placed in a situation where you're gonna be at disadvantage. So I just wanted to close with that, reminding that services and practice and communities are where change is gonna happen. The law is just gonna reflect that if we get there. Change, law can be a very strong tool for change, but really, when we see practice, it comes normally around.
Thank you very much, Alberto. Michael, you can give us your parting shot now.
I think for me, I want to look at post-COVID because I think this is something that continuously that, as advocates within the disability movement, we've been advocating for investment in community-based services. I think that for me is very, very key, looking at it, post-COVID, that we really need to invest in community-based services, specifically mental health services that are free from coercion, that respect the inherent dignity and the individual autonomy of persons with psychosocial, intellectual, and cognitive disabilities. And I think it's roll over beyond even mental health services. For example, we've been talking about inclusive education. And now with COVID, it's become such a big issue because it's not, education is not accessible, not only to persons with disabilities, but to, very, very many children, for example, in Kenya. And I think my argument is that when we build inclusive societies, then they do not only benefit persons with disabilities, but they benefit all of us. And I think also we need to act collectively going forward, build strategic partnerships to ensure the full and effective participation and inclusion of persons with intellectual, psychosocial, and cognitive disabilities. Thank you.
Ladies and gentlemen, thank you very much for a very engaging and very interactive session in legal capacity. I want to thank our panelists, Alberto and Michael Njenga. I also want to give my gratitude to our 2 sign language interpreters, Joyce Wangari and Julian Juma. We hope to see you again through and through in these Quality Rights interactive sessions. And thank you very much for participating. And to the audiences, thank you very much for keeping us busy. We hope to have a follow-up webinar on quality rights and mental health. And we also plan to have another webinar next week on a different discussion, but still on quality rights and mental health. Thank you very much, ladies and gentlemen, and hope to see you soon.